Number 63. One second, Counsel, just let's get the switch there. Okay, Counsel, you want any rebuttal time?
Yes, I'd like to reserve 5 minutes rebuttal time, please.
How much?
5 minutes.
Good, you've got it. Go ahead.
A statute is not retroactive when made to apply to future transactions merely because such transactions relate to and are founded upon antecedent events. This is a quotation from McKinney's Statutory Construction, Section 51.
But how do you tell whether it's operating on future or past events?
Well, the statute operates prospectively, but it is based on something
The statute says everybody who spits on the sidewalk shall go to jail. Well, spitting on the sidewalk is in the past, they're going to the jails in the future. Is it retroactive?
I'd have to know more facts about that to know how to interpret it. May I continue with my?
Sorry, go ahead.
But don't we start with the Majewski rule that we presume the statute does not have retroactive effect?
Yes, that is true, but
So what is it about this statute that would cause us to depart from the general rule?
because in
Or regulation.
every appellate case in the state and in federal jurisprudence that I have discovered that relates to professional qualifications, this is deemed to be not retroactive. I started with the
Well,
quote from
is this a penal statute? There's an allegation that it's penal in nature.
our position is that it's not penal, but that in itself is a retroactivity analysis, which this Court has said in its opinions in Forti and in Miller v. De Bono is not even required in the case of professional qualifications going forward into the future. But may I address the penal?
Yeah, please, go ahead.
Okay. First, I'd like to quote the U.S. Supreme Court, which said in Fleming v. Nestor, the severity of a sanction is not determinative of its character as punishment. Let's compare the consequences suffered by Mr. Nation in this case, who is prohibited from filing documents bearing his signature with the Department of Buildings for 2 years, with that of the petitioners in Miller and in Forti. Ms. Miller, a nurse's aide, having been found after a fair hearing to have abused a patient in her care, had her employment terminated as required by a statute adopted after the incident of abuse. She was then barred forever from employment by a nursing home in this state, but this court held that this was not a retroactive application of the law.
Isn't that, I mean, one distinction between the facts of this case
Yes.
and in the Miller case is that in Miller, wasn't it an across-the-board policy? I mean, if you were found to have abused a patient, you were not going to be able to work in a nursing home.
It was a mandatory statute, that's correct.
Correct? This is a discretionary provision we're dealing with
That is
here,
true.
isn't it?
Yes.
So does that make a difference?
I
I mean,
think
could the head of the agency here, could the commissioner go back and say to someone 20 years ago, you falsified something, so we're not going to let you work for 2 years in the future with us?
Well, the Department of Buildings is very dependent on working with professionals like engineers and architects. And so I think if it had only happened 20 years ago and there had been no untoward events since then, I think they would probably use their discretion to say
The
that
question is, could they? Would they be allowed to do what Judge Graffio said?
well, the statute is permissive. It's not mandatory. That is the difference with the Miller case. Let me go on to the Forti case, though, which is even more interesting, because he had not done anything wrong. Mr. Forti was an attorney who had previously been employed by the State Department of Environmental Conservation and who had left that agency to be the head of an environmental law practice in a private firm. The new law, which banned former employees of state agencies from appearing or practicing before their former agencies for a period of 2 years, virtually wiped out his practice for that time, which is coincidentally the same time that Mr. Nation is prohibited from filing. This Court held that this was not a retroactive application of the law.
When the person hasn't done anything wrong, does that make the argument for characterizing it as retroactive stronger or weaker? That is, well, you say, take a real obvious case of retroactivity. They decide to double the penalty for larceny tomorrow. And obviously, if that were applied to people who committed larceny before the statute, that would be retroactive,
That
right?
would be, definitely,
And those are
yes.
people who have done something wrong.
Absolutely. That would be ex post facto. As a
Yeah,
matter of fact,
so
because
that when you have someone who's done something wrong,
Yes.
aren't the retroactivity concerns more acute? In other words, isn't this a stronger case than 40 for considering the legislation to be retroactive?
I don't believe so, because you have Miller bookending it on the other end. You have somebody who did do wrong and was banned permanently from the profession, as compared to somebody who did do wrong and was basically unable to practice his profession.
But both of those are general statutes. As Judge Graffio said, on the one it applies to all abusing nurses, and the other it's going to apply to anyone who's is leaving or has left the government that wants to interact with that government. They're blind.
Yes.
In this one, you get to pick. And just as Judge Graffio said, you could pick and say, well, I remember 7 years ago something happened and I've decided I'm not going to accept anything from your office anymore. Or, as they're arguing in this case, it's much closer, but you've decided that you're not going to accept anything.
Well, that's an interesting question as to whether it would be more valid if it were made mandatory to anybody that was found guilty of false filing. But then again, you might have the problem of selective prosecution.
That's right.
because
You had an
decide-
option here, though. You have that professional certification, right? And that's what the problem was here. In your view, these people are not trustworthy. They cannot be trusted to self-certify.
Well, no. May I clarify?
Yes.
The law about limited supervisory check or professional certification was already in effect. It's not in question here, but it proved inadequate to solve the problem of false
What was
filing.
the purpose of the new addition?
The purpose was to take into account all of the filings, which are more than 50% that the DOB receives, that do not fall under the limited supervisory check.
But in which category is this guy was an engineer?
Yes.
Well, how does the new law let the department do anything to him that it couldn't do before?
Because there were 3 incidents that he was brought up on the charges in the oath trial. 2 of them would not have been covered under the limited supervisory check.
Why not?
Because it's just the practice of the Department of Buildings that certain types of applications for permits, probably deemed the bigger and the more important applications, are allowed to be this limited supervisory check.
Some are considered certifications and some are just signatures?
Yes.
And the
Please don't ask
Department
me
of
to
Buildings, for reasons we don't want to get into, draws that line.
Yes, and you will notice that the statute is couched in terms of any person, which would include the plumbers, the electricians.
Yeah, when I read the sponsor's memorandum, I thought that the idea of this was to extend the coverage to plumbers beyond the engineers. But you're saying that this used to only cover the engineers every other time, now it covers them every time?
Well, but the engineers do some things for limited supervisory check, and they do other things that do not fall under the limited supervisory check.
But to go back to my question, you could have said to all of your people, this architect, this engineer gets no self-certifications. I want every document that he brings in here to be checked and double-checked.
Well, we actually did that in the case of Mr. Nation, and he did not appeal from that.
But that's the point. I mean, that would have solved this problem, would it
No,
not?
it would not have.
Something would have slipped by your
Yes.
people anyway?
Two of the 3 incidents that the charges were brought on.
Where do you
would not
look
have been
then?
covered by the limited
I
supervisory
mean,
check.
if your people are looking at them and getting them wrong, I mean, are you understaffed? Is that, I mean...
Very understaffed, yes. And in the case of falsified photographs, they would have to actually go out and make a site visit to see what had actually happened there. So it's a matter of the resources of the department as well as the safety of the public.
But could you have said, we're not accepting anything more from your office before the statute?
Well, that's a counterfactual question. They didn't do it.
I know, but I think...
They went to the state to get the authority to do it.
But they're saying it's penal. And it seems to me that from your point of view, If you had said to your engineers, we're not going to approve these because, when you got floating garbage cans, it raises questions, so we're not going to approve a thing until we go out and visually inspect it. And I know that's going to take 8 months, but it's going to take 8 months, or a year, or 2. But we're not going to accept anything more from this outfit because of what they've done to us in the past. You could do that, couldn't you?
Well, I don't think with the resources of the DOB we could have done that.
Why?
In a practical sense. And
Why?
if we delayed the approval for too long, we could wipe out a person's business the same way. As
Wouldn't they be more careful about who they hired if they wanted to get it done more quickly?
Well,
Because
that is definitely the purpose of the statute.
Yeah,
Yes,
well-
that's what we're aiming at.
Counsel, anything else?
No, I'll be
Okay, thank you. You have rebuttal. Counsel?
Good afternoon, Gregory Cellino of Stewart Klein for Leon St. Clair Nation.
Afternoon.
The city's position is that this is a remedial statute and not a penalty. The express language of the amended provision states that in addition to any further penalty, it also was added as a subsection C to a code provision that where subsection A was a criminal penalty, subsection B was a civil monetary penalty, and they added subsection C, which says, in addition to any other penalty. I think statutory construction and common sense dictates what follows.
Could a legislative body say, as of tomorrow, anyone who has a conviction for endangering the welfare of a child may not work in a daycare center?
There are some cases that
Now, that would not be penal, that would not be retroactive.
Well, remember, in this case, unlike any case that was cited by the city, there's a substantive change in the law. At the time the acts took place, at the time all settlement negotiations took place, at the time of the hearing, Mr. Nation could lose his right to file any document only if he intentionally and knowingly filed a false statement.
Okay, so if we put it in the child, the law used to say anyone who intentionally abuses a child can't work in a daycare center. Now you change it to say anyone who intentionally or negligently harms a child can't work in a daycare center. That's retroactive? You can't do that?
Yes, under Landgraf, St. Cyr, and a number of state cases, that's a new penalty. It affects...
This statute talks about the division of buildings, I think. It doesn't say architects or engineers who do things are subject to penalty. It says to the commissioner, you can do these things.
Well, actually, what it says is that anyone who's found negligent, that had negligently filed a false statement after a oath hearing, the architect or engineer is the only person DOB has the jurisdiction to bring to oath that they don't license. Everyone else who goes to oath that's found to negligently file a false statement loses their license, therefore they don't file any more documents. They do not license the architect or engineer. The Department of Education does that. And that is part of the problem. One of the defenses that the city makes is that this isn't a new penalty. This is just the state legislature took an authority that the Department of Education had and transferred it to the commission.
No, it says it authorizes the commissioner to do certain acts. That's all. It doesn't say they can take your license. You can move to Buffalo and you can do everything you do now.
Right.
What it's saying is when you interact with us, because of what you have done, we're going to do various things. One of them was, I thought you could simply say, we're not going to trust you anymore. We're going to personally certify everything that you claim because we don't think you're being honest with us. They found you only negligent. And they could then take 6 years to do it. And there's not a darn thing you could do about it, is there?
No. Actually, Ms. Payer was incorrect in that all of these applications, which she was found negligent, were limited review applications. One was self-certified. Two, a Directive 14. It's a bit of a difference. I won't take up the Court's time. But they were all limited review applications. But under the education law, which the Department of Education, who has the authority to issue and regulate the license, there is no simple negligence. There is no one act. You cannot be charged with negligently filing a false
No, but
statement.
you're saying that the net result of what they did is taking away your license.
In New York City, which is where Mr. Nation
It's not true,
solely
because
practiced.
I assume you can do other things
You can do other things that don't involve the license that you've...
that don't involve the division of buildings.
I don't know what else you would do in New York City with an engineer's license that doesn't
You
involve
can
it.
draw a set of plans for somebody. If somebody, you just can't certify them to the Department of Buildings.
That would be correct. You can be a draftsman if you, but again, Mr. Nation was in practice for 20 years and has relied on the livelihood that a professional engineer, a licensed engineer.
Why wouldn't the rationale of Miller apply in this case?
Well,
I mean,
there's no
separate
substitute.
from the discussion that we had that this is not an across-the-board type of a
in Miller-
situation, but
In Miller, in fact, all the cases relied upon the city. There was no change in the substantive law. I mean, in Miller, the nurse physically abused a patient and was put on the registry. To be analogous to what's happening here, the law would change to say that if she verbally abused a patient, she can't work any longer. It was a substantive. I don't think you can get a more substantive change in the law than intentional conduct is actionable, and now it's negligent. I think that this is...
What was the change that was challenged in Miller? I'm not sure I follow your argument.
Excuse me, Your Honor?
What was the issue? What was the change that caused the problem in Miller? You say that the conduct was always...
If a nurse was found guilty of physically abusing a patient, she had to apply to a registry. I think in the Miller, the subsequent law said anyone who's on that registry can no longer work in a nursing home. Here, at the time these acts were committed, it was only intentional acts of which you could be banned for.
So you're saying that it's okay to increase the consequences of an act as long as it has some consequences to begin with?
Well, I think what this court said in Forte, and again in Miller, is that, if it's truly remedial, it may have some negative impact on antecedent events, but none of those cases had to do with the substantive change in the law that's in effect in the instance.
Well, was it really perfectly okay for your client to be negligent before this thing was enacted?
Absolutely not. In fact, well, if to put it
and
in
there's
context...
there was still previously a public safety concern if people doctored photos or falsified submissions to the
again,
building department.
At the time, as this court had stated, People v. Oliver, people guide their actions by the laws in effect. And at that time, it would be intentional filing of a false statement. It's easy to guide your actions. Don't intentionally file a false statement.
Going forward, isn't there a remedial purpose here?
There may be some remedial purpose.
And isn't this, in your words, just whatever tangential or a collateral consequence?
I think prospectively, I'm not challenging, although I know that some other parties in the lower courts are challenging this law on its face as unconstitutional. That's not the argument I'm making.
Yeah, but if it's okay going forward, and that's the reason as to what they're doing under 40, isn't that okay?
Well, there's a substantive change in the law, which under Mulligan v. Murphy...
Your whole argument rests on that.
Well, that and the fact that the
What
federal
case
cases...
stands best for that proposition about
if I
a
may,
substantive change in the law?
What Jacobus v. Colgate goes back to 1916, and Mulligan v. Murphy as well. And this court held in Majewski that if it's going to be applied retroactively, it cannot be equivocal. It has to be very clear. The clear language of this statement and the legislative intent is that it's a penalty. They could have amended if it was purely procedural and remedial, the state legislature could have amended a procedural section of the code.
Help me out with this. If the mayor says to his commissioner, the day you accept plans from someone that are either intentionally or negligently false, you're fired. Wouldn't the commissioner then say, I'm not taking any more of your plans, and there's not a darn thing you can do about it, is there?
If he had legal authority to do that.
I'm saying he's got legal authority. What's illegal about that?
If the mayor says any individual, just
No,
one
it says to
person-
the commissioner, you're going to lose your job if I find out that you've accepted plans from anybody that and those plans got to you either because they were intentionally mislabeled or negligently mislabeled. The commissioner is going to be pretty careful and say to his or her underlings, don't accept anything from these people. And that's perfectly legal. There's nothing you can do about that.
Well,
is there?
Well, yes. Well, for one, isn't that the jurisdiction of the Department of Education? They issue the
No,
license.
you get to keep your license. If
You're just out of business.
If the county of Erie tells me, we don't want you as a county attorney anymore, I can still practice law. I mean, you can go other places and do stuff. And they're not going to do that to you unless they think for some reason they have a right to, or not a right, but a reason to do it.
Well, The underlying record at the hearing, the department's expert witness admitted that 57% of their audit showed at least one major objection. In my practice, I know that usually there's many objections. So 60% of the applications filed by anyone in the city of New York have negligent filings of false statements, arguably. It's complex stuff. The New York City zoning...
Well, there's nothing complex about the 7 steps being missing in a photograph.
Well, Your Honor, my client, Mr. Nation, filed only for the curb. See, that was the whole, we didn't challenge the underlying action here.
No, I know.
But what they found wrong in those photographs, the department, in fact, didn't give it to us on discovery or at trial, that in fact, that those curbs were approved by the department.
They had pictures there, wait a minute, they had pictures there you saw where the same car is parked in the same place and the same pedestrian is walking with the same clothes on at 3 different times when they took pictures.
Well, no.
Now, it seems to,
That's
okay, well, it
just not
seems to me
accurate.
that at some point someone would look at these and say, you know, either this pedestrian is doing something strange
That's true.
or...
That photo, again, that photo is probably the exception.
But
you
now you're
talk
the
about
commissioner. Now you're the commissioner. What do you do in situations like that?
You report them to the State Education Department.
No,
and
you
they
don't.
can
You
take-
tell them, I'm going to report to the State Education Department if you don't clean up your act.
And you take away whatever rights you have, which was
Exactly.
his limited
Exactly.
review, which has been done.
Okay.
But that has been done. This is the additional penalty that didn't exist at the time the acts were committed.
Is there any, I mean, don't the authorities have some power to protect the public safety? So, you know, suppose we're talking about letting doctors practice medicine, and it's learned that a particular practice that hadn't really been, that no one had really noticed much before is very dangerous, and is killing people. And you say anybody who's made that before can't practice medicine. Are you saying that's unconstitutional?
I would think under Forte it would not be unconstitutional. However, again, your analogy doesn't have the substantive change in the law that's in effect here. In every case here, whatever they committed a Class C felony and had to register, that stays the same. This is the only case that, first, the only act was intentional. The law changed to punish negligent acts.
You know, negligence wasn't absolutely lawful in every way before this law changed.
I don't know.
The laws against negligence are not a novelty.
But, Your Honor, the
You
state
could do the
education...
sloppiest engineering work you wanted to do, and that was okay,
Well,
because it
Your
was
Honor,
negligent?
this gentleman filed thousands of applications, and we're talking about...
We're talking about the
two
rule
sets
that
of-
you're articulating here. I'm not getting the difference.
The rule I'm articulating is that the Department of Education punishes for pattern of negligence, for gross negligence, because engineers and architects make errors. It's complex stuff, and they punish them for that. The Department of Buildings, one act of negligence, they can now ban you from filing anything, essentially take you out of business in New York City. Mr. Nation's entire practice for 20 years is in New York City, and he's being punished for an act of negligence. That's not even recognized by the State Education Department.
Well, school districts can bar teachers who have certain convictions, certain types of criminal convictions, and the State Education Department licenses educators.
But I would argue, Your Honor, if the State Education...
It's not exclusive to one entity.
But if the law said that if you were convicted of a felony, you can no longer be a teacher, and then after you pled guilty to a misdemeanor, they amend the law to say felonies or misdemeanors, and now you can't be a teacher because you
So
pled to
you're
a
saying a school
misdemeanor.
district could not make a policy that it wasn't going to hire anyone with a misdemeanor conviction and apply that policy to anyone who already had such a conviction?
Retroactively, they could not. That would be addition of a new penalty. It was a
And what case says this?
Landsgraf, St. Cyr, all state that. In fact, if I may,
Well, Landgraf is just a statutory interpretation case, isn't it? It's not a constitutional case.
well, it's about retroactivity.
Yeah.
And in the absence of express language, if there's a new penalty, it cannot be applied. Landgraf specifically states that, if I may, that if it applies a new penalty, if there's a change in expectations, all of that happens
And that
here.
wouldn't be future professional eligibility under Miller.
But this isn't a professional eligibility case. That would be the State Education Department. This is filing documents with the Department of Buildings. So if the city's argument is correct, that it doesn't apply to professional qualification cases.
What if you just sort of, again, tangentially punished, but the purpose is, let's assume for the sake of argument, totally remedial?
Well, as this court held in Majewski, first of all, as this court held in Majewski, that if it's going to be remedial, it should say so. Clearly, it does not. The legislative history
Well, let's
says...
assume that the main purpose here is remedial. It's still no good?
No, because you've held...
Because of the substantive change?
That's one reason, and if it's going to apply retroactively, this court
Yeah,
says...
but if it's remedial, and you look at Miller and 40 and all of those cases...
I would say the substantive change, also the fact that they expressly label it a penalty. And this court has held, as the federal courts have, that if it's application of a penalty, it's not remedial. And there could be more clear language that this is, in fact, a penalty.
But isn't the real test the purpose of the statute or regulation? Isn't that ultimately the law?
And
What's the underlying purpose?
As it applies to Mr. Nation, I'm not exactly sure, because Mr. Nation is the only person who was found negligent, although dozens of people had been, before this law was passed, that's been banned. So I'm not exactly sure how banning Mr. Nation meets the intent of the law to begin with.
Okay. Thanks, Counsel. Counsel Roberto?
Can we pick
yes.
up from counsel's point? I mean, obviously, it's important that the city have, accurate and truthful documentation. I mean, that's a safety factor. We don't want cranes falling.
Safety
We don't
and
want-
resources, yes.
Yes. So let's pick up from there.
The false filing law was enacted to protect the Department of Buildings from the repeated false filings.
Well, Mr. Cellino, I think, makes the point that up till now, I guess they're the only ones. And the thought is this unfettered? The law comes in and the commissioner says, here's a person I've had trouble with in the past, I'm going to ban him for life. Is there any review of that type of a decision?
I do not know if my partner is an oath hearing, my co-counsel says.
I'm sorry, I didn't...
The solution would be an oath hearing, in which an independent hearing officer would decide whether this was a proper application.
There'd be a second hearing as to the penalty?
There would be a hearing as to that person, yes. Now,
No, I'm sorry, there's already an oath hearing here.
Yes.
And they made a finding of what I'll call liability for purposes of this.
Yes.
You then make this determination that you're going to ban someone for 3 years, or 2 years and 3 years probation. Do they get a second hearing on the penalty?
well, they get to submit their opinion on it to the commissioner. When the commissioner says what consequences he or she is deciding to impose,
Yeah, once she's made this
they get due process in putting in the response to
How has that occurred?
Well, it occurred in this case.
No. Stick with me. A letter comes out saying you've had your oath hearing, this is the finding, and we've now decided you're going to be banned from filing anything for 2 years, and there's going to be 3 years probation.
Yes.
And the respondent in this case thinks that's too severe. Is there a remedy for that?
Well, they are invited to submit their reactions to this.
All right, they do that. They do that, and the commissioner says, I'm not listening to you. I'm not opening any mail from your office anymore.
Then they have an Article 78.
All right, so the remedy is in Article 78 to do what?
Well, as in this case, a substantial evidence hearing as to whether there's substantial evidence that whoever it was actually did what.
No, forget that. Let's assume that's done. I'm talking about the penalty only.
Penalty only,
Yeah, the argument here by Mr. Nation is that you're running him out of business.
Yes.
Right.
And we say that we're not.
Right,
Because
and he wants to be heard on that issue, not on the issue of negligence. He says the pictures, and as he said, 57% of what you get is negligent or wrong. So he just says, I'm being singled out, this is too severe, you're ruining my business. Where does he go with that argument?
Up here.
And he argues...
He's having a hearing right now about that.
Thank you. Now, does that mean the Supreme Court gets to determine the severity of the punishment or of the penalty that you're imposing?
In the substantial evidence case, the Supreme Court passes it up to the appellate division.
Could the penalty be challenged as arbitrary and capricious?
Oh, definitely, absolutely.
What about the shocks the conscience standard? in administrative review? What would be the standard of review of the penalty in an Article 78?
Well, ordinarily in an Article 78, it is a shocks the conscience. And I'm not sure whether that has been decided in the context of this new.
What's your
false
sense?
pilot law.
You went in on this, if I remember right, saying that this was intentional, what was done.
No, I never said it was intentional.
Not you personally, I'm saying that
The charges.
the charges said
did.
intentional.
Intentional.
The judge, the administrative law judge found negligent. So it was
Yes.
less than you thought. At least the judge thought it was less than the commissioner thought. It was only negligence.
Yes,
So this is the penalty.
Yes.
He wants to say that's too much.
yes.
And you're saying that it's an Article 78 that gets referred to the appellate division, and they then determine it by a shocks the conscience standard, the penalty?
You know, the shocks the conscience question has not come up here, I believe.
That's what I mean.
He's so I haven't really briefed it in the context of this case. Naturally, my client does not believe that it shocks the conscience, and I don't think why it should, because
No, I'm looking for a standard. Is that the standard, or is it that the penalty, it would have to shock the conscience of the court for it to be changed?
I think that certainly could be raised by a petitioner in this case. This seems to be a hot question. It's not the
Okay,
first time I've been
Counsel.
asked about this.
We'll end on that note. Thank you
you.
both.